Yes, Mr. Reed.
My Lord, can I just begin by picking up a question with your Lordship in relation to the Commercial Court Guide? The relevant provisions are at J 8.1 and 8.6.
Never mind, just tell me what the answer is.
The answer is it's not in evidence just because it's in the bundle, and there are a series of provisions then about referring to it to closing submissions, referring to witnesses, and so forth. The mere fact that it's in the bundle isn't sufficient.
All right, thank you.
My Lord, can I then, for this afternoon, just begin with 2 points of clarification? I want to pick up a couple of points that were raised with me. One where I think I may have got it wrong, and if I had, I apologise, and what I want to do now is put it right. But so far as plenums are concerned, we address that at paragraphs 44 to 47 of our skeleton, which is at A, tab 10, pages 270 to 272. We accept that there was evidence of damage as at 2022, and it's right to say that Mr. Smith said that it was likely that damage would have occurred prior to 2017. However, our point is that Mr. Smith applied the wrong test, even if one adopts the judge's analysis of what damage comprises. Because he, in his analysis of damage, or approach to damage, that is Mr. Smith, included mould and included areas where there was a possibility of damage or potential damage, but not actually established damage. So that's our position in relation to plenums. On ground 5, it's right to say, as we've seen, that Mace pleaded the claim at 11 million. I think the claim of 9 or 10 million comes from agreement between the experts on the numbers.
Page 956
yes.
and 957.
Yes, I think that's Mr. Large's appendix, or appendix 9. That is the register.
It is, yeah.
And it's right to say that Mace did break that figure down. What we submit that they didn't do was establish that those numbers, those costs, related to damage that occurred prior to practical completion. That's the point.
Yep.
And look, it's not just that they didn't do that at the trial. There was then detailed argument thereafter at the consequentials hearing, and you can see it in the second judgment. The judge confirmed that his view, as expressed in his first judgment. That's at paragraph 28 of the post-consequential ruling. Now, my lords, because of the way in which the argument developed this morning, I think really your lordships have our points of principle, at least, in relation to grounds 1 and 2 of our appeal. There is, of course, more detail set out in our skeletons. Perhaps I can just give you the references to the skeletons. It's core bundle A, tab 11. And so far as ground 1 is concerned, pages 289 to 293. And in relation to ground 2, 294 to 298. But I should make clear, as I hope I have, that in relation to ground 1, we place principal reliance upon the second limb of the argument, which is to do with relevant damage.
Sorry, I was trying to catch up with you with listening to you at the same time, which is, I'm afraid, beyond me. Try that one again. Just
of course.
Sorry.
My lord, I was setting out where you could find in our skeleton where we addressed grounds 1 and 2 of our appeal. And the point I was making in relation
and
to
the
ground
page
1,
reference which I was trying to get to quickly.
Yes. So the insert in relation to ground 1 is pages 289 to 293, core A, tab 11. And ground 2 is in the same document at pages 294 to 298. The point I was making, my lord, that so far as ground 1 is concerned, what we place emphasis upon and what we focus upon for the purpose of the appeal is the second limb of that. And that begins at paragraph 33 of the skeleton, page 293. And that is the question of what is relevant damage for the purposes of a claim which is framed by reference to the cost of repair or replacement. Now, my lord, the submissions that I made this morning, I think, broadly cover the points of principle. The rest is detail. And in the interest of time, I'm not going to go through that. But can I just summarise it? It really boils down to this. Sky seeks the cost of repair or replacement, and therefore the only damage which is relevant for the purposes of occurring during the period of insurance is damage which requires repair or replacement. And we submit that the judge applied, therefore, the wrong test in relation to damage, And if we're right about that, we submit that that substantially undermines his criticism of Mr. Coulson, where he says that he adopted an impermissibly narrow test, because we would submit, if we're right on ground one, Mr. Coulson in fact applied the right test. And if that's correct, there'd then be no reason to look beyond the 2017 scheme as being or providing the appropriate measure for the repair and or replacement of damage as at the end of the period of insurance.
Can I just...
Go on. No, you go ahead.
No.
No, go on. I think we drew to the party's attention some authorities on what damage meant in the criminal authorities, which was, at least as I saw it, very similar to the test adopted by the judge of impairment of value or utility. But can I just focus then on impairment of value? Suppose that a homeowner in an equivalent position says, I'm not going to repair this myself, I'm selling the house, and the cost of repair involves the diminution in value. Does that make a difference? I mean, your argument seems to be you have to look at the remedy that's in fact going to be put in place by this particular
or
claimant.
At least the remedy that's claimed. The claim is for the cost of repairs.
Well, that may be,
and therefore we submit that the relevant damage therefore is that which justifies repair. And the examples, it was very helpful, the criminal cases that the court very kindly directed the party's attention to. Those are, in a sense, similar to, we would say, the Ordula case, where, and what I think is suggested in the criminal authorities is if you get the mattresses, the bedding, whatever it was, they were wet, something had to be done to them to restore them to their condition. And for the purpose of the Criminal Damage Act, that constituted damage. In the case of the Ordula, which I mentioned before, the hydrochloric acid was on the surface of the ship. That had to be removed. Mr. Justice Mann said that was damage because one had to expend money, time, whatever it might be, in removing the hydrochloric acid from the surface of the ship. We say fine, and if that's what was being claimed for, then that would be relevant damage. On our case, that isn't what's being claimed for. What's being claimed for is the cost of repair or replacement. By analogy with the Ordula, therefore, it would be whether, if they were claiming, for example, the dismantling or somehow the structural repair of the deck, as opposed to cleaning costs, merely identifying that something had got onto the surface, which needed to be wiped off, would not, we submit, be sufficient to support a claim for the structural repair of the hull, if in fact that had not, at that stage, suffered damage which justified any such repair.
does it follow from your submission that if the claim were for drying out costs, then it would be damage? But if the claim were for replacement, it wouldn't be damage, even though in both cases the commercial value of the property would be diminished.
It's not so much that it wouldn't be damage, it's a question of whether it's relevant damage. And we submit this, in a sense, there's no point in asking the question in the abstract, what is damage? What one has to look at is what is relevant damage, where should the focus of the inquiry be directed in a particular case. Now, if one takes the Ordula, it was relevant to look at the spillage of the hydrochloric acid, because what was being claimed for in that case, I think, was £11,000 odd of cleaning up costs to get rid of the hydrochloric acid. In the case of, for example, Blue Circle, where there were radioactive particles on the surface of the land, that was relevant because for the purposes of the relevant statutory regime. If you have a claim, for example, take a claim like Hunter and Canary Wharf, if what you've got is excessive dust on carpets, if what you're claiming for is cleaning up the carpets, then that plainly will be relevant for the purposes of that claim. If, on the other hand, you're claiming for knocking down the house and rebuilding it, the mere fact that you've got dust on the carpets plainly wouldn't be sufficient to justify that claim. And what we would say, therefore, is that that isn't relevant damage. When one then turns to the facts of our
I have great difficulty with that, I'm afraid. It seems to me that logically one starts with whether there has been damage, and then you move to a subsequent step, which is what is being claimed properly within the measure of indemnity, to put it loosely. And if the basis of settlement is cost of repair, then that's a question as to whether what is being claimed is the cost of repairing that which is damaged.
Well, it's the question of repairing the damage.
Yes.
And if all that's happened is you have wet timber, that wouldn't justify structural repairs.
Maybe so. All I'm putting to you is that doesn't mean that there hasn't been any relevant damage. It's simply so when one gets to the stage of the claim at which you're looking at whether what is being claimed is recoverable in respect of the damage. You look at it at that stage. This is expressed to be a question of what amounts to damage.
Well, that's the
describing it as relevant damage seems to me to be putting the cart before the horse. That's all I'm putting.
The what is damage, the broad question, what is damage, is the subject of limit. And in the example that you've given, I think I've said, well, in line with the criminal authorities that you've identified, in line with the case such as the Ordula, Mr. Justice Mans held that the cleaning costs reflect the fact that there has been damage, the fact that you've got to do the cleaning.
So to put you on the spot, you wouldn't cavil with the judge's criterion of what in the abstract constitutes damage in this context?
Well, in the abstract, but one wonders what the purpose of asking in the abstract might be. Because what you have to do is to ask yourself the question, what damage has to occur within the period of insurance, which by the end of the period of insurance would justify the remedy that's being sought.
Well, there's obviously an overlap between the point about developing loss. One has to identify some damage during the policy period for there to be any recovery at all.
Of course.
We then get on to a separate question.
Well, developing damage
in relation to
is a different thing.
Into measure of loss, which is why I say they are two quite separate questions. Firstly, is there any damage?
Right.
Secondly, if no claim, full stop. Secondly, if there is, what can properly be claimed in relation to it? And that's why I suggest that's the appropriate way of looking at it, rather than defining damage by reference to the remedy that's claimed. That's all I was cavilling with.
Well, my lord, that's very helpful. In a sense, I think that takes us to the same conclusion. So if the conclusion was that, or take a case where all that had been established was that there was some water on the cassettes as of 2017, but there'd been no decay at all. We submit it couldn't then be suggested that Sky would be entitled to the cost of repair, £196 million, because if we're right about the period of insurance, I quite accept that there's an issue about what is and isn't recoverable by way of developing damage, that they wouldn't be able to claim that money for cost of repairs in relation to something that has merely got wet.
Yeah, but that's a quantum point, not a damage point, isn't it? That's all I'm saying.
But look, we may be saying the same thing in a slightly different way. In fact, I think we probably are.
I don't think we are. I don't think we are analytically.
Well,
ground one is the judge got the wrong definition of damage. Now, you, I think, concede that he didn't. You say on the back of that, nevertheless, there's a point about relevant damage. And for my part, I don't think that falls within ground one at all. It's simply a point you're making about the quantum.
Well, my lord, we've expressed it, as I say, paragraph 33. We say that question, what the test for damage is, we submit it is ground one, because in order to identify the relevant test for damage, this is not, in the context of this case or any case, it's not, as it were, an exercise that's conducted in the abstract as to what may or may not count as damage. What one has to look at is what damage occurred that would support the remedy sought. To that extent, therefore, we say that because that was the test that the judge applied in order to test whether or not there had been damage which would justify repair as at the end of the period of insurance, then to that extent we submit that's the wrong test, because what he's not identifying is the damage that would justify what it is that was being claimed.
That's as it seems to me, is an appeal against his rejection of the 2017 scheme, which isn't a ground on which you've appealed or for which you have leave.
Well,
that's why I'm making the point.
Well, I can see that we didn't appeal it. We didn't put the appeal on that basis. What we said was that for the purposes of the claim, he'd adopted the wrong test. It was by reference to the wrong test that he then went on to assess what damage had occurred within the period of insurance. And thereafter, of course, consequences would flow from that. But what we do submit is that when you're looking at the test for damage in this case, what constitutes relevant damage to support the claim, then you do have to look at whether or not what is identified as constituting damage justifies the remedy. Otherwise, one's in the situation that I mentioned simply by reference to the ordure. You may simply have something on the structure, the surface of the deck, which would justify cleaning costs, but wouldn't justify structural repairs.
Well, I have to say I entirely agree with my lord that it's completely the wrong way around to look at it. You have to look at what is damage within the insuring clause, and then look at what remedy you're entitled to for that damage. Well, if you look at it the other way around, as you're doing, you're going to get into all sorts of trouble.
Well, my lord, it is taking it the way around that your lordship's just suggested, then what we would submit in relation to that is that if what the judge has found is that there is water in the cassettes, which if left might lead to damage, but as at 2017 had not led to damage which required structural repair, then we would submit that what the entitlement might be in those circumstances would be a remedy which reflected the presence of water, but not structural repair. Now, what Mr. Coulson identified in relation, by reference to the 2018-19 photographs, was that there was decay that justified structural repair, quite substantial structural repair, as at the date of 2017. That was the exercise that he carried out. But the test that was applied as to whether or not the damage justified it was precisely there. And it was the test that I suggested. It is the correct test for damage. That was the one that Mr. Coulson applied. It was on that basis that the 2017 scheme was arrived at. What the judge found was that that was, in his words, impermissibly narrow, and hence he adopted the 2018-19 scheme as better reflecting what he considered to be the correct scope of damage as of 2017. But, my lord, even on the test that's being set out, what one would then have to do is to say, well, what is the damage that existed as of 2017? What is it that is the remedy which reflects the basis of loss settlement, repair, replacement or reinstatement in respect of that damage as it was at the end of the period of insurance? And we would submit that if all that was there was water, then that would only justify drying out costs for which there's no claim. On the other hand, if what you're able to identify is decay, which affects the structure of the cassette, such that a cassette or a timber needs to be repaired or replaced, that's a different matter. And for that, you can recover the cost of repair or replacement.
So I'm sorry to interrupt.
No, forgive me.
So is the consequence of the argument on this level that the claim should fail in its entirety, or that the 2017 scheme should be adopted?
We submit on the basis that on this ground, the scheme that the judge should have adopted was 2017, because there would have been no reason to go beyond 2017 if he had applied the correct tests by reference to the remedy that was being sought. If he'd asked himself the question, what was the extent of the damage justifying...
Well, I understand why you say that.
Yeah.
I have to say that's not how I'd understood this ground.
Well, I'm so sorry. That's how we say you got the wrong test. Because it's quite right. You can say that. You can say in a given circumstance.
No. You say he got the right test. He gave the wrong remedy. You say.
Well,
is that not a fair way of characterising what you've just summarised to me?
It might need a certain amount of gloss, because what he needed to identify was by reference to the correct test, namely, had the damage by the end of 2017, or end of the period of insurance in 2017, had the damage progressed to such a state that structural repair was required. Now, then the next question is, well, if it has, to what extent? And we submit that the extent to which damage required structural repair as at 2017 was that identified by Mr. Coulson in his reports and reflected in the 2017 scheme.
Yes. So wrong remedy. Correct on his definition of damage, but wrong remedy.
Well, I'm not sure even correct on his definition of damage. Not the correct definition to describe or to ask what the relevant damage was as of 2017. Because simply to say, well, the test that he applied was water that might give rise to structural damage. What he should have asked himself was, what was the damage as of 2017 that would justify the remedy being sought? that would give rise to repair or replacement. Otherwise, there's little point in asking about water of itself if that wouldn't justify structural repair or replacement. What one needs to do in this exercise, we have Mr. Coulson coming along and looking at what the damage is, and as we know,
I'm sorry, it's my fault, but the 2017 scheme required some repair and replacement.
Oh, quite substantial repair and replacement, yes.
So that the damage which existed on your case at the end of the period of insurance was, to that extent, damage which required structural.
Yes. Oh, of course. That's our case.
Yes. And the judge, and therefore, if you're right on this point, that's the extent, you say, of damage as properly identified.
Yes, that's precisely it.
And then the judge found the cost would be the same after the drying out works in 2018/2019, and on that basis adopted the 2018/2019 scheme.
Yes.
Well, what's wrong with that on your case on this point?
Well, we say that the 2018-19 was a broader and enhanced scheme. We know that the judge has said there was some deterioration between 2018 and 2019, although he says that it wouldn't have affected the costs. But we submit that if he'd applied the right test, he wouldn't have needed to go to 2018-19. All that would have been required would have been to have looked at the position as of 2017. The scheme of Mr. Coulson, we say, the scheme based upon Mr. Coulson's evidence, addressed the damage as of 2017, and that would have been as far as anybody needs to go.
But that is as far as the judge went as far as damage was concerned. He only went to 2018/2019 because he said the cost is going to be the same.
Well, the reason he went to 2018-19 is because he said that Mr. Coulson had adopted there were two reasons, and I should set out both of them to be fair. First of all, he drew attention to the fact that there were only a partial amount of photographs. There weren't photographs of the entirety of the roof. Yes. Only some cassettes. He was concerned about that, and one might be able to see that. But there were quite a lot of photographs, but not comprehensive photographs. And secondly, he was concerned that in his view, Mr. Coulson, when identifying what damage was, had adopted what he referred to as an impermissibly narrow test. And our submission is no, he hadn't. For the purposes of the claim, he had adopted the right test, because only by applying that test would you identify that extent of damage within the cassettes which required the repair and replacement for which Sky and Mace were seeking indemnity.
I think I have the argument.
Well, I'm grateful for that. My Lord, with that, that really is the principle. Can I then move?
Just before we launch off, can I just ask you, hopefully you can do this quickly, is mineral wool a red herring?
Yes. Okay. There's no claim on its own.
And that's why you say, because presumably the mineral wool was removed as part of the drying out process, and presumably fresh, non-slumped mineral wool was put back in.
I think up to a point. I'm not quite sure the precise details.
I think it sort of must follow that you don't try and dry out. I mean, my understanding was looking at the judgment that you remove the wet mineral wool insulation before you try and dry out. It's a bit pointless otherwise, if you can. Presumably you open up and fish it out and then dry it out and then put some new stuff back in. You say that, in a sense, we can forget that and we don't need to think about the question about whether the cassettes as a whole were, quote, damaged because part of their integral structure, namely the mineral wool, part of their design, part of what they are, like the insulation was wet. You say we can ignore that. We can ignore the question of whether that was damage within the meaning of the policy because they haven't claimed for the costs of hooking out the wet mineral wool and drying out.
I think it's right to say
right?
I think it's right to say there's no discrete claim for costs associated with mineral. What, as I understand it, is claimed.
Who did pay for that?
I think the drying out work was done by Prater. I can't give you a definitive answer now as to what payment was incurred in relation to.
But you say that's not part of their claim, therefore the interesting question about whether that would constitute damage doesn't arise.
It's not so much that it's not part of their claim, it's simply there's no discrete claim for mineral, as I understand it, separate from the overarching scheme for repair and replacement. That I think is the point.
So the crater drying out costs aren't part of anybody's claim, is that what you're
They're
saying?
not part of the claim of these proceedings, no. No. And all that which is, forgive me.
As I understand it, the cassettes are wet inside. If not dried out, they're going to rot, or there's a risk of that. But you say the answer to that is they can be dried out, and so there is no damage or no damage sufficient to justify the claim. But what then happens is if drying out doesn't work? Doesn't that mean, and then it proceeds to rot? Doesn't that mean that as at the date of that we're looking at, the end of the insurance, they are wet, they're going to rot, and they do rot? Why is the answer to that they can be dried out if in fact drying out didn't work or wasn't done, when you don't criticise the drying out exercises that were done?
We don't. No, but the answer, I think, is that what you have to look at is, was there damage as at that would justify replacement or repair as at the end of the period of insurance?
Yes.
And the position remains that if all you have in the cassettes as at that date is water, and the answer to that question is no.
But we may be assessing the damage at the end of the period of insurance, but we're entitled to look at what happened afterwards in working out the nature of that damage. And we know that damage is going to cause rot. And you don't criticise the steps that were taken. So we know that the state of the cassettes as at the end of the period of insurance was such that it was in the event going to cause rot. So why is that not damage which justifies repair? Because you know, with hindsight, and you're entitled to use hindsight for this purpose, it was damaged in a way that was going eventually to need to be repaired.
It answers the question. You look at the position in 2017. If what you have in 2017 is simply water in the cassettes, then the position there is that isn't something that at that stage would justify repair. What it would justify.
Well, it will if it's going to cause rot.
But that's not what you know at 2017.
But we're not limited to what. Why? Forgive me. Why are we limited to what we know in 2017 when we're assessing in 2023 what the damage was in 2017?
Well, the answer is that isn't not something that has occurred within the period of insurance. Go back to the point I was making.
It did occur. It was wet.
The wetness
was wet within the period of insurance in a way that we now know is going to cause rot.
But nothing that occurred within the period of insurance, which as at the end of the period of insurance would have justified repair or replacement.
You do. If you know it with hindsight that it's going to rot, it is justified to repair or replace it because it's going to rot.
Well,
and we know that because it did.
It rotted eventually, but the rotting, the thing which required replacement on the example that you've given, happened after the period of insurance, and that's
so what? Because we now know, and I'm still not understanding why one can't use what we now know. We now know that it will rot, and you do not criticise the steps that were taken. So there was damage, according to the judge, in 2024, which was, as a fact, going to cause rot. Why doesn't that justify repair or replacement?
Because by 2017, it hadn't developed to the stage where you did need to repair or replace.
So what? We know that it will.
But one asks oneself, what is the position of 2017? And if at 2017 somebody was able to look at this problem and say we have water in these cassettes, at that stage, repair and replacement would not be justified in drying out wood.
Well, if somebody was looking at those cassettes at the time and you were able to say to them at 2017, I'm really sorry, the water's got in there, it's not going to be possible to dry them out before rot develops, what would they say? Okay, we're going to have to deal with that. Why isn't that justifying repair or replacement?
I think that our answer to that would be simply that there was not damage that would justify repair or replacement as at the end of the period of insurance. And that is
So
the only
even
damage.
though, with hindsight, they knew that they weren't going to be able to dry it out, they're only entitled to
Yes.
drying out. Well, that can't be right, can it?
Well, we submit that there has to be damage which justifies repair or replacement by the end of the period of insurance.
Thank you very much.
Can I just ask one further piece of information? The judge's formulation of what constitutes damage,
Yeah.
was that his own formulation, or was that a formulation that Sky or Mace put forward? You can come back to me on that.
Well, look,
I'm just interested
I
in
think
a
the
matter
answer to
of
that
information.
is that it was his own. I don't think anybody put the specific formulation that he adopted as part of their case. Submissions, to put this in context, the parties adopted rather different approaches to what damage might have been. This was the answer that he adopted. We said that it had to be structural change. A different proposition was put forward by the claimants, I think.
All right, thank you.
Well, with that, if I may now turn to ground 4. And this is the question of the second trial. Now, my Lord, we contend that the judge was wrong to order the second trial. But although it's been described as an assessment of damages, it's quite a lot more than that. Amongst other things, it's going to involve expert evidence from experts in 5 different disciplines.
That doesn't stop it being a quantum question.
Well, it's
I mean, using expressions such as second trial or whatever, I entirely understand, but it's just a question of whether he was entitled to look for further assistance on quantification, isn't it?
my Lord, I'm happy to approach it on that basis, but perhaps the substantive point might be this: that what is going to be involved with 5 experts, construction management, engineers, as well as quantum experts. And the reason for that is working out the implications of a scheme that the judge devised himself and for which nobody contended. And I wonder whether I can just go through that background to see to where we got to, and to how we got there. So, Lord, the directions that the judge has given, as I say, to the trial. This was after a unitary trial, 5 weeks back in January 2023. There was oral evidence, as I've indicated, from 14 witnesses, 6 witness statements received, and oral evidence from 16 experts over the course of 14 days. Now, we say, subject to our grounds 1 and 2, what the judge ought to have done is assess damages on the basis of the available evidence by reference to the 2018-19 scheme which he had fixed. That's subject to my grounds 1 and 2. And indeed, that is what he said that he would have done if he was to decide the case by reference to the available evidence. And he said that in the second judgment at paragraph 18, and perhaps I can just invite your attention to that.
I'm sorry, what was the reference?
It's paragraph 18 of the judge's second judgment. It's at page 443.
So sorry, I'm in the wrong one.
I wonder whether perhaps you'd be kind enough to look at paragraph 18 and perhaps 5 or 6 lines down. I consider that it would be entirely appropriate to conclude that Sky would be entitled to recover whatever unadjusted value should be attributed to the 2018-19 scheme. And that was in the context of a submission that if I was right, and there is no evidence that can or should be permitted that enables the effects of previous conclusions to be assessed, this is what he would have done. And he says that this would be a straightforward application of the point made by Lord Justice Leggett at paragraph 53 of his judgment in Nagel, at the relevant part of which I quoted from earlier, and would involve me assessing which of the 3 experts' valuations was to be preferred, ignoring the conclusion I've reached on the issues of principle, by which he means the functionality of the various schemes, and the fact that he thought that the 2018-19 scheme needed adjustment in order to be an appropriate scheme. But my Lord, the point that I emphasise here is that on the basis of the available evidence, what the judge said that he would have done is to adopt the 2018-19 scheme without his own suggested amendments or revisions, and that then it would be a quantification exercise in relation to that question of quantification having been addressed at some length by the quantum experts during the course of the trial. Now, my Lord, we say that therefore that is the course that he should have adopted, subject to my points in grounds 1 and 2. What he did instead was to decide that the correct approximation for the assessment of damages was a hybrid scheme which was of his own devising. No party had contended with a scheme that the judge eventually adopted, and indeed Skye positively eschewed a hybrid scheme as being dangerous. No party had cross-examined a witness or expert by reference to that scheme, because it was a scheme that the judge developed in the course of his judgment. And more than that, it was then necessary for further directions to be given for the experts to work out all its implications, not only as a matter of quantum, but also as a matter of engineering and construction management.
I mean, those are two separate points, aren't they? I mean, the mere fact that it was a hybrid scheme, as you describe it, doesn't mean that it's impermissible from the judge's point of view. I mean, every day of the week you have valuation disputes where one expert says this and the other expert says that, and the judge says, well, actually neither of them is completely right. I think the actual value is somewhere in the middle. But the mere fact that the judge isn't bound to assess damages or valuation or whatever on the basis of one or the other, it's quite clear. You can, having heard evidence, choose something else. And that's the first point. And I thought your second point is, yes, but you can't do that if you haven't actually heard evidence which allows you to get there.
Well, there are a couple of you might be right that there are 2 points wrapped up. But, my Lord, the position here was that the judge devised a scheme that no party was contending.
Right, well, that's the first
He
point.
was presented with 4 schemes.
But is he in... Okay, the mere fact that nobody contended for the scheme that he arrived at, the mere fact of that can't be a ground for appeal, surely. It's how he got there, whether he was entitled actually to get there is the ground of appeal, isn't it?
Well, I think we might submit that if you have 4 parties, I'll come to some of the evidence. Skye, for example, made a great deal of the fact that schemes had been the subject of an enormous amount of technical evidence. For example, I'll take you to it in a moment. That they made the point that technical experts and more than 25 consultants and contractors had been involved in devising, for example, their scheme. Now, at the trial, after a great deal of time and expert involvement, the parties put forward before the judge 4 schemes. And my primary submission, my Lord, is that it was incumbent upon the judge to choose one of those.
In its entirety, without modification?
Yes.
No matter what he thought about it, he just had to go for one or the other?
Well, can I just perhaps invite your attention to how he did it? Could we go to the judgment just to see what the judge said about it?
How he did it, I accept may be the subject of complaint, but are you saying that a judge is straitjacketed by the schemes put forward by the parties and he just has no discretion to deviate at all from one of the 4?
Well, my Lord, it might vary on the circumstances of particular cases, and it may be that one struggled to lay down an absolute rule of that sort. But in circumstances where what is in issue are matters, for example, of structural engineering, and where the evidence is such that doubt is cast on mixing and matching schemes by the structural engineers involved, in those circumstances we submit that it's incumbent upon the judge to adjudicate on the schemes presented to him, not to devise a scheme of his own. And can I just put it in context of what the judge said? Could we go to his main judgment, paragraph 222?
You're going to have to provide is there an authority that says that? Is there is there some principle of law that says that?
Well, I'll be taking you to authorities concerned with the adversarial system. And what it is that the judge has to do is to determine on the basis of the cases that are presented to him and to prefer one case or the other. And we would submit what he's not to do is to devise his own scheme. There are further aspects to that, because one of the consequences of him devising his own scheme is that neither party had an opportunity to make any submissions about it or read evidence and so on. But that's a separate point. But could we just see the paragraph in which the judge made his decision? It's paragraph 222.
This is all to do with the assessment of damages, right?
Well, one says this, that's where it leads to.
Well, that's what he's doing.
Yeah.
He's assessing damages.
It's assessing the indemnity.
So your proposition is that a judge assessing damages, or the amount of the indemnity, is bound to select one or other of the opposing parties' contentions as a matter of law.
If the indemnity or the damages rests upon particular schemes for which the parties are contending, and in such a context, then we submit that that's what he should do, yes.
And what's the difference in type or principle between that and hearing expert valuation evidence of, for example, as to how to value the shares in the company, which are the subject of a damages claim?
That doesn't involve any engineering on the part of the judge.
Oh, what's special about engineers? I think some share valuers might think they're quite expert as well.
But what they're valuing is something which is pre-existing. This was something which the judge devised during the course of his judgment. No,
not necessarily. You could be valuing shares on the basis of the future anticipated profits, which is always, to some extent, speculative.
And what about personal injury claims, where there's a catastrophic injury and a very complicated assessment of how to quantify the whole life care that's needed in forms of various different forms of care.
But that would be on the basis of the cases that the parties were putting forward as to the care that was required.
Well, not necessarily. The judge might get to a stage where he says, well, in relation to these complex needs, in relation to one particular discipline, the claimant's expert has said this is the appropriate solution, the defendant's expert has said this is the appropriate solution. I think it needs fewer of these number of qualified people and more of these at a greater for a greater number of hours. Can he do that? And if he does that, is he bound to have a stab at it, which he would undoubtedly be entitled to do, is he not entitled instead to say, well, can we have a further hearing now that I've told you that of the many different combinations that might have arisen, that's the one we're going to have, and can the experts now please tell me what it would actually cost for these kind of qualified people for these number of hours within these parameters?
But the problem with that, though, my lord, is that is putting forward a scheme for which nobody's contended, and that was in the teeth of expert evidence suggesting that mixing and matching.
No, sorry, but in my example, the judge would be entitled to do that. Yes?
Well, one can see how there might be circumstances in which a judge is entitled to do that. But my submission here...
And you say this is different because it involves structural engineering?
This is different in the sense that what the judge did was devise a scheme for which nobody contended and for which there was expert evidence suggesting that it would be unsafe or potentially unsafe and shouldn't be done. Now, if one could look just at paragraph 222...
I hear the second bit of that. Yes. There's the second problem, and I was desperately trying to identify whether you're making one point or two. And your first point seems to be a hard-nosed, procedural, substantive principle of law as to what judges are entitled to do or not. The second one is much more, was it right for him to do it on the facts of this particular type of case? And I'm trying to nail down whether, in fact, it is your first submission that a trial judge, hearing a claim for damages based upon expert evidence, is just not entitled to do anything other than accept in full one or other party. Because if that is your submission, I'd want to see some principle or authority. Because I think I've certainly given a judgment to the contrary effect.
I'm sure there's plenty of authority to the contrary.
Yeah.
You may be driving towards modifying the submission and contending that that's the position on the facts of this case. But I will be taking you to authority in relation to the duty of the court to adjudicate upon the dispute framed by the parties, as opposed to the court trying to conduct some sort of inquisitorial procedure in order to get to an answer for which neither of the parties is contending for. Now, we do rely upon those authorities, and I will be taking you to those. But can I just focus for the moment on what happened in this case and why we say this was not the right course, and why it is that what the judge should have done was determine the case on the available evidence. And if we could just look, please, at paragraph 222, at page 435. What said is that although it was submitted by Sky that the schemes could not safely be mixed and matched, I don't see why that's so. At any rate, in the way that I've done, this submission ignores the fact that the defendant's scheme is simply a method of attempting to quantify its liability. Giving effect to the 2018-19 scheme but with temporary roofing and crash decking does not compromise but enhances safety. That was the view that the judge formed. Can we just look, please, at what was said by the parties? Could we go, please, to Supplemental Bundle A, tab 8F.
Just to be clear though, when the schemes couldn't safely be mixed in that, what do you mean? That's ambiguous. What do you mean safely be mixed in that? Do you mean couldn't be mixed and matched with if they were in fact going to be performed, that people in the building would be safe? Or are you saying they couldn't properly be mixed and matched as a juridical concept?
It was simply that as an engineering proposition, that the schemes couldn't be mixed and matched, or at least that gave rise to risks. That was the aim. Yes.
Safety,
Yes.
health and safety.
Yes, well, or structural safety.
Okay, safety.
No,
Yeah.
Right. Now, can we just look first of all at page 107 in Supplemental A, tab 18.
This is Sky opening, is it? Sky closing?
Yes, Sky's written closing
Closing.
sequence.
I mean, what page?
Page 107, behind tab 18. First of all, Mr. Murray is referred to paragraph 167. There's reference there to his evidence where he says, I consider the risk of a repair solution to be unacceptably high. So that was the starting point for Sky. And then, please, if we could just go to paragraph 225 of page 109.
So, and the risks there he's talking about are not safety risks, they're just not success. Is that right?
It require unrealistic efforts of cost and time, yes. Yeah. And then, please, if you go to 109, what this does at paragraph 225 in the submissions is to set out a passage from the third report of Mr. Murray and Mr. Davis, the structural engineer and architectural experts for Sky. And at 4.3, what's said is, generally speaking, and bearing in mind the level of complexity of the remedial schemes that have been proposed, I do not consider it reasonable to mix and match different aspects of the schemes without due consideration to all of the potential design and construction related consequences. I state this because each of the schemes has been developed with a different basis or intention in mind. And then 4.4, down at the bottom, mixing and matching specific aspects of the different schemes can therefore be very complicated, can necessitate other significant changes to the schemes.
So that's all to do with what I'd call question 2, or submission 2. Given these particular schemes,
Right. Yeah.
you shouldn't
have done it.
You shouldn't have done it because it actually produces something that doesn't work. Not the judge just can't do it as a matter of judicial approach.
Well, Lord, certainly so far as this particular scheme is concerned, we rely upon that to say this is not something that you should have done in the circumstances.
Although that's not focused on the particular aspects that the judge identified. That's a general.
No.
That's
whether we can, I'm just slightly mindful of the time, Lord. I think I've got about half an hour, and there's quite a bit more less than that, and quite a bit to go through. Can I just take you to some of the references that we rely upon? Paragraph 228 is where Sky set out how much time and money has been spent on the devising of the schemes. And what's said halfway down that paragraph is that it would be wholly impractical to suggest that some form of ad hoc combination of schemes be created at this stage, leading to yet further investigations, analysis, uncertainty and delay, and so forth. This attempt to do so would not be a matter of quantum alone. It would be to reopen structural construction management programme and other issues. And although there was reference to a hybrid scheme at 229, that was not the one that was devised by the judge. In fact, it was the opposite of it. That was the application of the insurer's temporary works with the permanent works of Sky or Mace, whereas in fact the conclusion or the solution which the judge devised was the permanent works relating to insurer's scheme together with the temporary works, a combination of which was suggested, or a combination of those suggested by Sky and Mace. Now, the position was, as I mentioned, that nobody had contended for the scheme that the judge devised. What I want to do now is just look at how the judge approached it. Could we go, please, to paragraph 186 of the judgment?
Is that it, on the evidence that mixing and matching that the judge shows would be unsafe?
That's the position. And I should say, well, that evidence that I just referred to doesn't go as far as unsafe. What it goes to say that there will be engineering difficulties that will have to be worked out. I can't put it as high as that on the basis of that. But, my lord, what then the judge did is to say at paragraph 186, he would invite further submissions, with the parties then being encouraged to agree the financial effects.
Sorry, does what you've just said mean that you withdraw the suggestion?
I don't think
it couldn't be safely done.
I don't, on the basis of that evidence, I don't think I can say that what's being said there is expressly said to relate to safety.
No, nor do I. And is there any other evidence on which what you previously submitted was based? Slightly unsatisfactory.
Yeah. Well, Lord, I think perhaps that the highest I can put it, if I invite your attention again to paragraph 222. He refers to a submission that the schemes could not be safely mixed and matched on the part of Sky. But what he doesn't do is explore what's meant by that. But that was the submission that was made by Sky that is recorded by the judge.
Yeah, but you've shown us them. You've shown us where that came from.
Those are.
Yep.
That's my suggestion.
All right.
Now, my lord, if then one looks very quickly at 186, we can see that what he had intended to do was to hand down the judgment and invite submissions as to quantum. And then, 5 or 6 lines down, he says that the parties he hopes that the parties will now be able to agree the financial effect. So that's what he had anticipated would happen at that particular point. However, by the time we got to the consequentials here, it had become apparent that an expert evidence was going to be required in construction management and quantum, and that was then provided for in the judgment. Thereafter, in the second judgment, the judge said, and I can just give you the reference, at paragraph 21 of his second judgment, he referred to there being multiple different possibilities. I think he said 40 different permutations. But earlier in that judgment, he himself had identified that there were only 4 schemes. And in his first judgment, he'd referred to the fact that there were rival schemes put forward by the parties. And that is paragraph 5 of his second judgment, paragraph 18 of his first. And Mace, for example, in their closing submissions, paragraph 3.8, supplementary bundle A, tab 9A, page 120, indicated that the court has before it 3 schemes. The judge then, perhaps I can just take you very briefly to how matters unfolded. If we go, please, to the second of the post-judgment rulings. during the course of the post-judgment rulings, there is a development of a theme whereby the judge says that the defendants put forward their schemes very late. In fact, the judge gave permission for the defendants to put forward their schemes in August 2022. But my submission would be that that isn't a fair criticism of the defendants. They were put forward in accordance with directions which the judge gave, and those directions subject to variation but the PTR as a consequence of the amendment of the Mace scheme were complied with. Now, what then the judge does in Judge 3 is go on to say, paragraph 20, and perhaps I can just invite your attention to that. He says, 7 or 8 lines down, secondly, on the conclusions I have reached, the work done in respect of the Sky and Mace schemes has been entirely unnecessary and a waste of time. And then at paragraph 35, be good enough please to turn just to page 465, that he says that the problems come about because the defendants chose to give evidence which was fatally flawed. Paragraph 35. And what then happened was there was an expansion of the evidence. Initially, limited permission was given for experts, and then in January 2024, that was expanded to cover 5 expert disciplines. Now, we submit that in doing that, there were 3 substantive errors that were committed by the judge. First, that he failed to have regard to the principle of finality. Second, that he failed to have regard or to give effect to the duty to decide the evidence or decide the case on the evidence that was available at trial. And then third, failed to have regard to the adversarial system. Now, my Lord, in the interest of time, I wonder whether perhaps I can take this relatively quickly in terms of the references. The principle of finality is articulated in pretty clear terms at paragraphs 241 to 242 in the Sainsbury's supermarket case. That's at tab 63 of the bundle. And also in the case of AIC, that is tab 69, where the point was made that parties have to bring their whole and best case, that the trial is the first and last night of the show. It's not a dress rehearsal. We submit that in not deciding this case on the basis of the evidence that was available, and in other words, adopting the approach that was set out by Lord Justice Leggett in the case that I referred to, then in those circumstances, the judge erred. That is what he should have done. There was the material there. And indeed, in the first post-judgment ruling, he said that if he had been driven to decide the case on the evidence, what he would have found was that the 2018-19 was the appropriate scheme without his amendments, and then would merely be an exercise of quantification, which the quantum experts had already done. My Lord, the second principle we say that is engaged is the obligation to do the best you can on the available evidence. What really he should have done was choose between the 4 schemes that were presented as representing the correct measure. But in spite of referring to Nagel, he doesn't do that. We submit that that is an important principle, and that the judge should do the best with the material available, and for which there is a long line of authority, including, for example, the one-stop case or the one-step case that we have in the bundle at tab 54. And the relevant paragraph in that decision is paragraph 38. My Lord, we submit that if the judge can always ask for more evidence, then the requirement for the judge to do his best is to some extent undermined. He can always ask for more if there are inadequacies in the evidence before him at the trial. And we submit that the approach that he adopted offended against the principle of finality and undermined the principle of doing your best. We submit that sets quite a dangerous precedent. It rather suggests that there's some sort of discretion, as opposed to simply doing the best you can on the information that the parties have presented.
This is case management.
Well,
It is, and that is a discretion.
Well, my Lord, our submission is that these are substantive principles, but if I'm wrong about that and it is a case management decision, then we say that he was wrong as a matter of case management. But my Lord, we say it goes rather further. These are fundamental principles which are set out in the authorities to which the court should have regard. Matters as much as anything else of public policy. And we submit that the judge didn't take any of these. There's no reference to the judge taking these matters into account. He simply came up with a scheme for which nobody had contended. And by then, it was too late for the parties to do anything about it. All that was left was for the experts to try to work out the implications of that on a technical basis, and then for the quantum experts to try to quantify it. And we submit that is not the right approach. And we say it's quite unlike the position in a case such as Lynch, the Hewlett-Packard case, where the quantum issues there were expressed not to have been the main issues in the trial, and the judge set out in very clear terms that he needed further assistance. That was at paragraph 3, subparagraph 5 of the judgment. That's at tab 74 of the Bundle of Authorities, page 1949. In this case, by way of contrast, in the second judgment at paragraph 2, the judge made it plain that in reality, most of the trial and all of the evidence has been taken up with the causes of failure and what remedial works needed to be carried out. And we would submit it's quite a different question, having heard all that evidence, to then say, oh, well, there's just not enough there, I need some more. He's already said that he could make that decision by reference to Nagel on the available evidence, and we submit that's what he should have done.
In one step, the trial judge adjourned off the quantum issues.
Well, but my lord, the principle that you should do your bit, that's all I get from that case. But lord, I understand.
But you say the judge didn't have this in mind. As I understood the sequence, he sent out his judgment in draft, and then there was a hearing.
Yes.
And he deliberately didn't hand it down before that hearing, the hearing at which there was the application to dismiss the claims for not having proved the case, and so on. And everybody said, you can hand it down. And that was the hearing at which he considered all these principles you've been identifying about having to bring forward your case all at the same time, and so on.
Well, I think we got the judgment at that stage, and then those submissions were made at the first consequential. I think that, well, it was the first consequential hearing when those submissions were made. I think. Now, I might have got the chronology on that wrong, but I think that's the position.
Well, I'm looking at what's called the head of the post-judgment ruling, which I think is what you've been calling the second judgment.
Yes. Yes.
In which he says he's got to consider that the submissions that both the Sky and Mace claim should simply be dismissed for having failed to prove them.
Yeah.
And in which he sets out the legal principles in relation, for example, at paragraph 13, page 441, generally the task for the court to make whatever findings it can, and deals with paragraph 53 of Nagel and Shenik and so on.
But that's after the principal judgment, in which he says, well, I think what ought to happen now, I have devised a scheme.
But not before you were given an opportunity for him not to hand that judgment down and to consider it amending it in the light of what you had to say. As I understand it, but do tell me if I'm wrong, I thought the way matters went was he deliberately not handed it down, having sent it out in draft, until he got to the consequentials hearing. He then said to the parties, can I hand it down?
Yeah, that is right.
And you said yes. Now, if you wanted to say, no, wait a minute, well, you shouldn't have done this, and what we're going to say today is why you shouldn't have done it, which actually was the position. You had the opportunity to do so. So to say, well, it was all too late by then because he'd already hit upon his hybrid scheme, well, I think a little unfair to the judge.
Well, Lord, I don't want to be unfair to the judge, and it's right to say that the submissions that we made at that hearing were for dismissal. That was because at that stage the judge hadn't indicated that what he would have done on the available evidence is to adopt the 2018-19 scheme. And as anticipated in the judgment, we, I think, had indicated towards the end of the trial that if he were to find that the claimants didn't succeed on those schemes, then that may well be a submission that we make. But my Lord, what we say is that, looked at overall, if the judge was going to propound this particular scheme, at the very least, it's something which ought to have been canvassed with the parties, and it ought to have been something upon which either they could make submissions or lead evidence or cross-examine in the ordinary way. But what in fact the parties were presented with was a scheme that nobody had contended for, that the judge had devised and referred to for the first time in his judgment.
But you had, my point is, you had the opportunity. You could have said at the consequential hearing, please don't hand it down. You've devised a scheme which is a wholly inappropriate mix and match. We just haven't had an opportunity to address you on that, and please don't hand it down until we've sought to persuade you that that isn't the route you should go down. And that was the opportunity that the judge deliberately gave you by not handing down, wasn't it?
Well,
I mean, what?
I'm not sure. I'm not sure it presented itself to us in that way, but that's not at least the position as we understood it.
Right.
Now, whether that is right or not might be a different question. That's certainly not we.
Leave aside what the judge's intention was, but
Quite.
There was the opportunity.
Well, perhaps we could have said something then. But either way, what the judge did was to devise a scheme for which nobody contended and for which nobody was then able to make submissions. And we submit that is the thing that distinguishes it from a case such as Lynch. Lynch, of course, as you know, the quite exceptional case. One could get that. I think we've included just simply the index to the judgment in the authorities bundle, which stretches to a very long number of pages.
Yes.
And I think at paragraph 7, Mr. Justice Hildyard makes it clear how exceptional it was.
But as I understand it, you have essentially 3 points. You have the 2 points that my lord has identified. One, this is wrong in principle. If you're presented with 2 alternative cases, you've got to choose one or the other. Secondly, on the facts of, if that's wrong, on the facts of this case, it was wrong for him to do what he did in relation to adjusting 2018, 2019, because you didn't have an opportunity to address it, and whether that was a sensible answer, to which the answer may be, well, you did, because you were offered the opportunity beforehand. And then your third point, I think, is, in any event, if it's case management in relation to how you go about it, he didn't have in mind the principles that you've been identified, notwithstanding that he seems to have recited them in his second judgment.
Well, it's certainly not that when he, at the time he formulated his first judgment. Well, I've made a submission. Yeah. My Lord, just in terms of the adversarial system, can I just give you a couple of references on the authorities? Again, it's Sainsbury's, those same paragraphs, they cover both finality and that system, at tab 63, 1610. The reference in one step, tab 54, is paragraph 38, page 1351. And then, so far as other authorities concerned, I think just one more I referred to, Lynch. It's the case of Ali and Dick. That is at tab 70, the bundle, page 1841. That was the case in which the judge decided the case on the basis of an arrangement which hadn't been pleaded and had been expressly disavowed in cross-examination. Now, it was found, I think, on that basis that on that particular case he was entitled to do that, but certain general principles were set out relating to the way which is described, I think, was reference to the third man. The general thrust of it is that the judge should not come up with a solution of his own for which nobody's consented, at least without giving the parties a chance to make submissions on it. So, my Lord, those are the relevant authorities. Now, I have 10 minutes to introduce retained liability, I think, before I have to hand over to Mr. Reed. I wonder whether perhaps with that I could just turn to retained liability, if I may.
Yes.
Now, my Lord, for this purpose, I think what I need to do is just invite your attention to the relevant clauses in the policy. Could we go, please? You've seen the insuring clause. Could we please then look at the risk details, page 749.
It's 769.
749. No more. I do apologise.
Mr. Ridley, I am contending with quite a bit of noise out here.
Oh, I'm so sorry, my Lord.
No, I can just say occasionally I'm struggling.
I'm so sorry. So page 749. This sets out in the risk details the insured's retained liability. You can see the first entry there is £10,000 each and every loss. And then it said, however, in respect of defective design, materials or workmanship, the following will apply where option is selected by the principal, and that's £150,000 any one event. But this will only apply to those claims which are recoverable under DE5 and not under DE3. Now, my Lord, I think common ground, as noted by the judge, is, between the parties, is that DE5 applied, and therefore the applicable retained liability in this case is £150,000 any one event. Now, my lord, can I just then take you briefly to show you where DE5 is? You can see that at page 771. And you can see that what it provides for is an exclusion, first of all in relation to the costs necessary to replace, repair or rectify any property insured which is defective in design plan specification. And my lord, that's a reflection of the fact that this is a property damage policy rather than a professional indemnity policy. And then at subparagraph B, loss or damage to the property insured caused to enable replacement, repair or rectification of such defective property. But then it goes on to say, but should damage to the property insured, other than damage as defined in B above, result from such a defect, this exclusion should be limited to the cost of additional work resulting from and the additional cost of improvements to the original design plan specification. So, provided that you have damage as a consequence of the defect, then that which is excluded is what's set out in that paragraph. Now, my lord, the other clause that I need to take you to very briefly is the 72-hour clause on page 777. As you can see there, that provides as follows. For the purpose of the application of the insurer's retained liability, and my lord, it's because of those introductory words that this clause, we say, is of particular interest. It is agreed that any damage to the property insured or liability for damage arising during any one period of 72 consecutive hours and caused by storm, tempest, flood, water damage, subsidence, etc., shall be deemed to be a single event and therefore to constitute one occurrence. So, just looking there, it's agreed that any damage which occurs within the 72-hour period shall be deemed to be a single event and therefore a single occurrence. Now, my lord,
and what's the significance of the words "and therefore to constitute one occurrence"? Does that have any significance for this policy?
Well, we will submit, linguistically, it does, we submit, in that this refers to, you will appreciate that in the risk details that we just looked at, there's a reference to £10,000, and that's a reference to loss.
Yes.
150,000 expressed by reference to event. Here, what is said is that for the purposes of the 72-hour clause, if what you have is damage, or all damage within the 72 hours, is to be regarded as an event and therefore an occurrence, it appears as if what that is saying is therefore that the occurrence would then attach to either the 150,000, in other words, an event is an occurrence, or alternatively, if the applicable retained liability was 10,000, any one loss, then loss would also be an occurrence.
Does the one occurrence wording apply in the retained liability clause?
No.
Because I've seen lots of these hours clauses,
yes,
and they're often in excess policies because the definition is series of occurrences.
Yeah, it's not.
So that looks as though that's something that's just been lifted out by mistake from.
Well, or alternatively,
it's not pertinent to the retained liability in this case.
Well, what I think might be pertinent to is the meaning for the purposes of the retained liability of words such as event, occurrence, and loss. I'll be submitting in due course that they are.
Forgive me.
The same way.
For the purpose of the retained liability clause, I can quite see you say this is important for the meaning of the word event, which is the event that is covered there, and you may say it's important for the word loss.
Yes.
But since the word occurrence doesn't appear there, how can it be important for the meaning of the word occurrence in the retained liability clause?
Nothing beyond the fact that which is said to be an event is therefore said to be an occurrance. But simply to say that at least this clause is not drawing a distinction between the one and the other.
Why is that relevant to this policy?
Well, it might not make an enormous amount of difference, but
doesn't make any difference. I mean, what I'm putting to you is that seems to be superfluous wording that's just been left over from adopting part of a standard clause. That may or may not matter, but isn't that the case?
But it may be that you're thinking of the sort of example that Mr. Justice Foxton gave about patchworks in insurance policies. It may be. It may be. But look, can I just take you to one further provision? And that's General Memorandum 6.
Yep.
Could you look, please, at page 7 and 9? Again, that is expressed to relate to the application of the insurer's retained liability. And what's said is, in the event of damage or liability occurring where more than one insurer's retained liability applies, the total amount deducted in Section 1 shall not exceed in all the highest applicable insurer's retained liability. So, fairly standard provision perhaps. However, in the case where exclusion 1 to Section 1, known as DE5, applies, insurer's retained liability in respect of DE5 will only apply to the damaged part, and the normal contract of insurance insurer's retained liabilities will prevail for all other damage. Now, my Lord, those then are, but we submit the key provisions for the purposes of this aspect of the appeal. My Lord, as I say, it's common ground in this appeal that DE5 applies, and therefore the relevant retained liability is £150,000 a year of debt. Now, we submit that the difference in the magnitude of the retained liability by reference to DE5 as opposed to the ordinary £10,000 reflects the fact that this is a policy which is primarily concerned with damage, not with defective design. And so, in other words, yes, you can have cover for defective design subject to the terms of DE5 and the incidence of damage and not being able to recover improvement costs, but only as part of a commercial allocation of risk, one of the aspects of which is that the retained liability is higher by reference to DE5 than would otherwise be the case. So if what you have is a case of damage which is the result of defect in design workmanship, then you have a retained liability of 150,000. If, on the other hand, what you have is damage without such defect, then the applicable retained liability is £10,000 per occurrence. Now, my Lord, what I'll be submitting...
Per loss.
Per loss, forgive me, yeah. Now, my Lord, we submit that although, of course, by reference to the authorities, words such as occurrence, event, loss, they have been explored at some length in the context of particular policies. But, my Lord, I think it probably is right to say that those words, they're not defined by authority, and their meaning isn't cast in bronze, because their meaning might depend upon the particular combination in which they are used in a given policy. Now, my Lord, it's right to say, I think, that in very broad terms, one thinks of a case such as AXA and Field. Lord Mustle made the point that there is clearly a difference between a word such as event or occurrence, where that's describing something that happens at a particular time, particular place, particular way, and something such as cause, which, at least on the face of it, Lord Mustle said imports a much wider amplitude, and that is something which is very much broader and potentially is capable of looking retrospectively back in time to see what the cause of events which might have occurred later might be. But Lord, we can go to AXA and Field in due course. Perhaps I can just give you the reference to that from now. It's in the authorities bundle at tab 14, and the relevant passage where Lord Muscle distinguishes between events and cause is at 194. But what I wanted to do was just show you how sometimes the words can be used quite fluidly. Is if you'd be kind enough, please, just to look in our skeleton argument, and if you'd be kind enough just to turn to our footnote 19 at page 305, Core Bundle A, tab 11, page 305.
So just give me that reference again.
Yes, it's page 305 and footnote 19 in our skeleton argument. Core A, tab 11, page 305.
Yes, I'm there now.
Now, my Lord, what we've done is set out various wordings from particular cases, not because we say they define the meanings of the words, but really to illustrate the point that words such as occurrence and event can take their colour and meaning from the combination of the words in which they're used. So, for example, if one takes a case such as the FCA case, as your Lordship know, Lord Leggett and Lord Hamblin said that in general terms, occurrence and event are synonymous. But it may be that what they had in mind there was if they were used on their own. So if one talks about an event or an occurrence, one's talking about something that happens here and now. One could get combinations of clauses which talks about occurrences arising out of an event, where one might say, well, the meaning of event and occurrence are perhaps not synonymous. And an example of that, 4 lines down, you'll see the reference to Dawson's Field, cited by Mr. Justice Ricks in Kuwait, and then we've got a clause there, each and every loss or accident or occurrence or series of thereof arising out of one event, and then above it, in Dawson's Field, each and every loss and or occurrence and or series of occurrences arising out of one event. Now, my lord, I don't rely on that for anything other than the proposition that in order to test and to construe the meaning of these words in a particular policy, you have to look at how they're used in the policy and look at the words, rather than saying it is a rule that one of these words means X or one of these words means Y. Now, look, what I would like to do, if I may, is just invite your attention very briefly, and I know Mr. Reed's looking at me, I think he probably thinks I've run on too long already. I wonder if I could just have 2 or 3 minutes just to set up this point, and that it may be that I have to come back to it in reply, but just so that I can identify what we say the mistake is that the judge made when arriving at the proper construction of retained liability.
Yes, I think it's rather unfortunate. Carry on for another 5 or 10 minutes.
It's 5 minutes.
I think it's a matter for the court. I'd personally rather hear the case now rather than find a new case and reply.
And my reply is going to be
shows
brief on what I've heard. But Mr. Mace saved 10 minutes of his time for later.
Yes.
So that's what.
Yeah.
I mean, I have to say, the use of the time is for the parties. I am rather surprised that you've left this point on which a huge amount of money turns.
My lord, I can make clear, whilst I thought I might need the time, having heard what's been said, I don't, and within reasonable proportions, if Mr. Wrigley finishes this point, it's more important.
All right, let's get on. I'm afraid 4:15 is a hard stop today for us.
What I wanted to do, if I may, is just take you very briefly, please, to the MMI case, because not only was that concerned with developing damage, it also said something about aggregation clauses. Could we just please go to tab 20 in the authorities bundle? Now, your Lord, at page 392, you can see there that the clause that's under consideration has this language: in respect of or arising out of any one occurrence, or in respect of or arising out of all occurrences, or a series of consequence unattributable to one source or original clause. Now, what Lord Justice Hobhouse said was this: it's into this wording that the reinsurance contract excess is imported. So if the reinsurance contract, the first year, there's an excess of 500,000 for compensation, payable in respect of any one consequence, etc. He then says, if this was a simple any one event clause, the defendants would have a powerful argument. They could say that each act of pilferage or vandalism was a distinct event. And then he goes on to say, but this clause is not in that basic form. So my lord, the first point is, our clause is in a basic form. It's any one event, along the lines that Lord Justice Hobhouse said. Now, I know that
Any one event clause, not an originating clause. I think we needed to go to MMI for that. And you really need to get down into the nitty-gritty of the argument.
Well,
The first question is, does event in the retained liability clause refer to the loss, or does it refer to the cause of loss? That's to say, the defective design, workmanship,
Precisely.
or materials. And then the second question is, if it means the latter, what is the unity of place for the purposes of event?
well,
Those are the 2 points.
Yes, and my lord, that's precisely what I was going to say. Can I give you references to what the judge did? Paragraphs 96, 30 and 33. We say that he assumed that what he had to inquire about was the underlying cause of what happened, as opposed to looking at simply what happened. We say that the clause any one event does not invite an inquiry as to what the underlying cause might be.
Well, that depends on what the event is that you're talking about.
We submit that it merely invites inquiry as to what happened. And indeed, that very broadly is the approach that was adopted by Mr. Justice Riggs in Kuwait Air. What he did was look at what happened at the beginning of August, and what he said was, what happened is that the airfield was seized. There were 15 planes, 15 losses, but the event, the occurrence, the thing that happened, was what happened immediately there and then. That was the seizure of the airfield.
So you say that in the retained liability clause, in relation to the 150,000, the word event in substance means the same as any one loss.
Well, we say any loss, event, occurrence, by reference to the 72 hours clause, we say that event means an event of damage.
Yes. And how do you explain that a different word has specifically been used in the clause?
It has been used, but given that if the relevant retained liability was 10,000 any one loss, that also would be an occurrence for the purposes of the 72R clause. The retained liability of 150,000 any one event is described as an occurrence as well. We submit that those words are interchangeable, and we say that the relevant event is an event of damage to a cassette. These are cassettes, I've said, 472. They are set out over a very large roof.
How does the damage occur to the cassette?
The damage occurs by the incidence of decay. The underlying cause of that, at least on the claimant's case, is something that happened years previously.
And the incident of decay?
Yes.
What do you mean an incident of decay?
Once the decay has reached a stage that you need to repair or replace it, that then is the damage in question. And once that damage has happened, that is the event of damage to which the retained liability applies.
So if we look at the unities, the famous Lord
Yes.
Mustell unities,
Yes.
unity of time,
No unity of time because the damage happens in different cassettes at different times and in different places.
but unity of time within a particular cassette. So if it takes between the ingress during construction and the end of the period of insurance, period of some years, that's sufficient unity of time, is it, for all the
There may be
all the damage in one cassette to be one event?
We would say that simply adopting a pragmatic or common sense view, the relevant unit of measure is the cassette. Now, that to some extent involves a factual question. It relies
Sorry, you're not answering my question. The relative unit of measure as the cassette is concerned with the unity of place.
Yeah.
I just want to focus for a moment on whether you accept that there is unity of time for a particular cassette in relation to the damage which occurs over the whole of the period between ingress during construction and the extent of decay at the end of whatever the relevant period is, take it for the moment, period of insurance.
The cassette, instances of damage within the cassette take place over time.
Yeah, say over 2.5 years, but
Yes.
but
Yes.
that 2.5 years is one event, is it?
Well, we would say that what you do is you look at, once a cassette's damaged, that is an event of damage, and we say there are as many events of damage as there are cassettes.
No,
that have become
please, Mr. Wrigley, will you focus on my question, because it's quite important for reasons I'll come on to. Do you accept that if you take one cassette, and assume they're all different, that there is only one event of damage, notwithstanding that it takes place over a course of perhaps 2 years, the entire period up to the end of the period of insurance? Is that sufficient for the unity of time?
I'm not going to submit that that there's more than one event of damage per cassette. We say pragmatic.
So you do say
there's one
2.5 years, say that's sufficient unity of time for all the damage from that ingress to be one event for each cassette, yes?
I'm not sure I'd express it in terms of unity of time in arriving at what the relevant damage per cassette might be. Of course,
Well, you have to have unity of time. You have to have unity of time as one of the unities. And there's a reason I'm pressing you on this. Do you submit that there is the unity of time within each cassette or not?
Well, the submission is not so much expressed by way of unity of time. The submission, first of all, is to say, before one gets to looking at unities, one has to look at, first of all, what the event might be. And what we submit is, by reference to the 72R clause, the relevant event is the event of damage. One then has to say, well, if there has been damage, what then has happened? Has there been damage to the roof? Is that what one says? Or do you say, in the context of 472
No, please, Mr. Wrigley, there's a reason I'm pressing you, and I want to know what your case is as to whether, assuming you're right, that you have to look at it cassette by cassette,
Yes.
the period of time over which the damage in a particular cassette occurs means that all of that damage is one event. 2.5 years worth of deterioration is sufficient unity of time to be one event.
Well, can I actually
Yes
slightly
or
different
no?
way?
Yes or no?
Well, So far as a cassette is concerned, yes.
All right, thank you.
In relation to the cassettes as a whole, no. And the reason for that is we say that the cassettes, which we say are the relevant unity of property, they became damaged at different times. And so far as they are concerned, different bits of property, they are not united by the
If damage occurring over the whole period within a single cassette can constitute sufficient unity of time to be one event, how for what reason do you say that unity of time is not fulfilled by damage to other cassettes over that same period of time?
My Lord, perhaps I ought to refine what I said in answer to your Lordship's question. It's the moment at which one cassette becomes damaged. In other words, the decay is such that structural repair is required. That is the event of damage that counts.
Sorry, say that again.
When you have one cassette that sustains damage, in other words, it requires structural repair, we say that that is the relevant event of damage. And we'd say that as between cassettes, there is not unity of time because the damage occurs at different times in different cassettes.
No, but within a single cassette, it happens over a period of time. What do you mean it's when it occurs? Within a single cassette?
To look at the relevant event, what we say is you simply have to look at when damage first occurs, damage as I've defined it, or suggested one defines it. When that occurs for the first time, we say that's an event of damage.
When it occurs for the first time,
Yes.
rather than when all of it occurs?
Yes.
You say, I think, when the decay has reached a sufficient point in time at which repair is necessary, as opposed to just drying out.
Yeah.
That's the event,
Yes.
the one and only event.
That's the event of damage.
Even though there is subsequent damage, which is a different event?
Or prior.
Is that a different event?
Yeah, or prior decay which doesn't amount to sufficient damage to require repair or replacement.
We say it's the event of damage that requires repair or replacement.
It's hitting that golden moment at which that's the event, is it?
But that's the event. And we submit that the
So what is the subsequent damage? Is that a separate event, is it? So within a cassette, you've got two events.
well, on one view, one might say that you have. As far as this particular aspect is concerned,
Do you say that?
But
The reason I'm pressing you is this, that it may well be that the analysis is, because you have to have unity of time, even if you look at it within each individual cassette, if what event means is the loss, as opposed to the cause of the loss, you either haven't got an event at all, or you've got multiple events within each cassette, which would lead to a very odd result.
Well, I understand.
And that's why I'm pressing you.
Question.
And that's why I'm pressing you.
I know you're.
I know you want to jump straight to unity of place, but we may need to pause because the logically anterior question is event talking about loss, or is it actually, because it's specifically in the context of a particular cause of loss, namely defective design workmanship, is it actually looking at the defective design or workmanship? That's one of the main fault lines between the argument.
It is. And we submit that the approach of the judge to go immediately to questions of causation relating to design and workmanship, that's an inquiry which isn't prompted by the wording of this clause. That the wording of any one event prompts an inquiry as to what happened, as opposed to what the underlying cause of it might have been.
Yes, well, what happened was he said defective design. That is what happened. The issue is is the inquiry directed at what happened in relation to the cause or what happened in relation to the loss? And the argument against you is one part of the clause says loss. This says event, not loss, in the context of a specific cause.
I understand that.
And simply saying that the judge didn't go to what happened, meaning what happened in terms of loss, just doesn't engage with the argument.
But perhaps the 72R clause does, because that, as you know, is in the policy there for explication as to the retained liability. And what that says is that damage occurring during that 72-hour period will be treated as one event. So we submit that what the meaning of event is an event of damage. Now, the only reason for relying on the 72 hours clause is for linguistic construction interpretation. We don't rely on it for any particular 72-hour period, but it's simply to say that when this clause, which is concerned with the retained liability, refers to damage, that is said to be a single event and therefore to constitute one occurrence. And we say that on the basis of that, then what the policy contemplates is that an event is an event of damage, and it's against an event of damage that the retained liability applies.
I understand that submission. Thank you.
Lord, I've already used up more than the very generous offering that the stuff really gave me. I probably better yield.
All right. Mr. Reed.
Well, I can be relatively brief. There are a number of individual points arising out of Mr. Rigney's submissions, which I want to go back to. I'm acutely conscious that the majority of the points are being dealt with on behalf of Sky. I'm not going to cross over those. Firstly, in relation to the point that Mr. Rigney made about not having had an opportunity to make submissions in relation to the judgment, I hear a slight echo of something I was saying to my Lord Popplewell earlier about it being submitted in draft. And I'm acutely conscious that paragraph 1 of the first supplemental ruling did indicate the judge had in mind receiving any comments prior to handing down. The only difference between Mace and the other parties, of course, is that when we received that judgment, the judge had already concluded the only thing that Mace was entitled to was declaratory relief. And to make any further submissions would necessarily require Mace to go behind that decision to open up matters. So there was an obvious constraint there. The second point Mr. Rigney made was in relation to the memorandum of policy, when he said they had been specifically negotiated between, I think, Sky and insurers. Mace would, of course, wouldn't know about that, but general condition 23 of the policy, Core C 797, paragraph 23 says, the text of the contract of insurance is the text of insurers. So, at least from the perspective of Mace, when it gets the policy and reads the policy, it does so knowing or believing that was not necessarily the subject of negotiation, but the wording of insurers. In any event, I don't push that too far because I'm not sure where it takes anyone. The third point is with respect to the definition of damage advocated by the parties. And if one goes to bundle B in our reply, 537, page 537 of the bundle, rather, I'm going to go straight to 674.
So 574.
So it's 674, I think it is.
6.
Just give me 1 second to make sure I've got the right reference.
Sorry, what are we going to? What document?
Yes, that's my, I think the best place is to go 674, do forgive me.
Sorry, which bundle? Which
It's
document?
bundle B, our amended reply.
Thank you. Yeah.
And it's both relevant to my Lord's question, but also to one of the points that we make in relation to investigation costs, where we broke down the definition of damage in our reply as requiring a physical change which affects use or value. And then we go over the page, usefulness, and we explain was not limited to its function, or included function, maintenance, liability and durability. C, again, value in a second paragraph is not limited to the effect of the unremediated damage will have on the value of the insured property to a purchaser or its value as security at the date of the damage. In other words, that says as a matter of obvious inference, if you try and either sell or secure a building which has a roof full of water, that may affect its value as security. The next one was D, is not limited to reinstating the anticipated functional components of the property. And finally, E, which deals with the cost of the investigation, and it's a loss incurred in response to, consequent upon, and by reason of a physical interference with the property insured as a result of the water ingress. And what that's perhaps convoluted wording for saying water ingress, which affects the insured property, is a physical interference, and that's sufficient. So I'm not sure, I'm sure the judge didn't use those words. He used his own words, but the substance of it is similar.
So what's the point you're getting at?
Well, simply, I think, I wasn't sure, my Lord Popplewell wanted to know whether the judge's finding of the meaning of damage in paragraph 117 of the judgment was one advanced by a party. I'm doing the best I can. I think we came close to it.
I understand.
The next one, again, my Lord Popplewell raised the question of fortuity.
I'm Lord Justice Popplewell.
Lord Popplewell. Forgive me for that rudeness.
So, some wouldn't treat it as rude, but you are perhaps right. Yes,
I just need to gather my thoughts for 1 second. Yes, with Mr. Rigney, and I hope I address him correctly. The question of fortuity has particular resonance with a contractor in a construction project. And the reason is perhaps obvious. That during the currency of the works, the possession of the property is normally with the contractor. And on practical completion, it passes to the owner, operator, or another party. And as between the contractor and the employer, the building now is third-party property. So the contractor has to have a form of insurance which ensures its liability for damage occurring either during the maintenance period, however it's defined, defects liability period, has to have its own public liability insurance. It cannot get any public liability insurance for that period if there's no fortuity, or if it does get cover, it simply won't pay. And therefore, knowledge of damage occurring, or knowledge of damage as at practical completion, or the continuance of that damage or the development of that damage, if it's inevitable, or whatever phrase one wants to use, means that no contractor could gain insurance for that risk. And that's why we would respectfully suggest that the remedy for the developing damage and the risk is best placed with the all risks construction insurer, who at the time of that policy inception is obviously never going to be any issue of fortuity, really, because the construction has never started, never commenced. So it was to place the emphasis more on the contractor, we would say, although I'm sure the employer has their own insurance issues, which would give rise to it. So then moving to insulation. Now, insulation was something that was pleaded by Mace as an aspect of damage, expressly. The insurers made no admission in relation to that, pending expert analysis of the provenance characteristics and specifications thereof, and that's in their re-amended defence, paragraph 17.2. They then said, they then denied that any reduction in thermal performance per se constituted damage unless it compromises the function of the cassette, as a result thereof requires repair. And the key words were per se. So it really wasn't advancing any case except one of principle. And
sorry, I missed the reference. I was still trying to catch up with 13.2.
Yeah, it's Core B, Divider 22, page 566, paragraph 53. Accordingly, so we say the judge was required because of that to make of those pleaded points as to whether wetting of insulation which reduced its thermal performance was per se damage. With respect to the evidence, I'm going to give my Lord's references. On the 7th of April 2015, wet insulation was notified with standing water found inside the gutter compartments of cassettes. And you'll find that in the judgment of paragraph 14, but it's also supported and comes from the expert evidence of Dr. Paul, paragraph 6.4.7, in supplemental D, divider 45, page 767. Insurers called a Mr. Grinter, who was a Prater employee, to give evidence, and he gave evidence over in his role overseeing the removal of wet insulation prior to practical completion, and that's in the transcripts. Supplemental E, divider 20, page 986. Mr. Wellesley Smith gave evidence which was unchallenged on this point, that thermal performance is materially impaired immediately upon wetting of the installation. And you find that in supplemental B, divider 40, 388, in fact all the way through to about 462. And that's unchallenged evidence both in cross-examination or contrary positive evidence. My Lord's attention has been drawn to the fact that Mr. Coulson did not give expert evidence on the issue of thermal performance because he said he was unqualified to do so. Mr. Jessup accepted that on remediation of the roof, it will be necessary to replace the insulation in areas of repair. That gives rise to two types of insulation case. One where as part of a repair you have to replace the insulation, and two, the insulation per se, because of its loss of thermal properties, requires to be repaired. And we say both there was a pleaded case and an evidential case on that.
But that he means replacing the sound thermal insulation that had replaced the wetted insulation, which, as a result of the drying out works.
Yes, it's repairing the insulation, all the insulation that's had some water in it, and that has an immediate effect because that's a property which is insured. I'm not sure.
I think you only need to replace it once, though. I think.
Oh yes, sorry. Do forgive me. My point is this: that if you have a scheme such as the Mace scheme, which requires all the cassettes to be opened up, lifting the lid to see whether there's damage, you would replace any of that insulation which has suffered that reduction in thermal quality, irrespective of whether there is other physical damage in that cassette.
So in other words, you'd say, okay, lift the lid in inverted commas. I appreciate that's more than just lifting a lid.
Yes.
If when you look inside there is damp insulation, you would replace it,
Yes.
irrespective of whether any of the structural timbers or the OSB is either decayed or warped.
Indeed.
In other words, you wouldn't leave damp insulation where it is.
No, because its properties have been compromised already.
Yeah. And just blowing air over it doesn't really help you because it will have compressed.
That damage has already occurred. So it's already taken place because that compression happens when the insulation becomes wet.
Yeah.
those points were all contained in our both written and closing submissions, which are in the bundle, and you'll find it as supplemental A, divider 9, 147 to 151.
Did the Mace scheme include identified costs for insulation replacement?
It assumed, yes, it did. I can't, well, off the top of my head, be precise that there's a line item for it, but I can be absolutely sure that it included for replacing the insulation.
In every cassette?
In every cassette.
But I think that was the point. I mean, it didn't actually say a line item replacing.
No, and I don't think it did. I can't be 100% sure. I'm pretty sure without looking, it wouldn't have done.
Well, why not?
Well, just because it was a cost of doing the whole work. Because we have a cost for lifting the lid, looking inside, putting right any damage, and it's part and parcel of that. I'm just reminded it's part and parcel of the hybrid scheme as well, as I understand it. But that's wherever you lift it. But it makes that's a slightly different point. The point I'm making is where there are no other physical repairs, the insulation has to be replaced. The reason why insurer's case was never going to be well founded is they had an impermissible narrow definition of damage. So in a sense, it never really arose on their case. So without wishing to
Sorry, what?
their definition of damage always involves some sort of structural element, and insulation was never going to fulfill that criteria.
Oh, sorry, it's the structural part
Yes.
rather than the timing point. Okay.
And the key point, I suppose, is this. That is also something, because of the nature, the immediacy of the effect, was damage as at practical completion. Turning to incurred costs. I understand that the key point that's now being taken as against Mace could be described as linkage. It's saying, accepting that they were pleaded, accepting that they were identified as categories, accepting the quantity surveyors agreed the figures as figures, but saying we failed to identify which costs were incurred in respect of investigations for the relevant remedial scheme. And the first...
No, it's a timing point. Which were investigations in relation to damage which occurred prior to practical completion. That's as I understand the argument.
Yes.
You failed to identify what, if any, part of those could be so attributed.
The timing point, of course, I quite accept that we have to identify costs that go to the damage in the remedial scheme as at practical completion. But that is not the timing of when they're incurred, because a lot of the costs are incurred in finding that damage where it is. For instance, the Mott MacDonald costs are an obvious example. They were opening up the cassettes or taking photographs, doing moisture readings and producing rag maps. And so it's no answer to say that you haven't identified precisely with that particular date and time, because it's obvious that when one is doing that exercise, it's a matter of inference. Here is the information which we have discovered, and indeed what these experts did. Can you decide as best you can when damage first occurred? So we say the strict time cutoff is not the relevant question. The relevant question is on linkages, our simple question is, were these works necessary for the purpose of identifying damage at that date? The oddity of all this is that...
Does that assume you're right on the question of the timing of loss which falls within the policy.
Yes, but of course, if we are also covered for continuing damage on my analysis, then it's the investigation of that as well, because that's all part and parcel.
So when you say yes to my lord, the argument you advance is addressed to the premise on which the judge was working, namely that the only recoverable damage is that which has occurred prior to completion.
It is.
Yeah.
But I did also make the point, of course, it must apply by parity of reasoning to any developing damage. A reference was made in this respect to the recoverability per se in an extract from Collinvoe, which wasn't pressed too hard, and I would simply make the point in relation to that extract that what it's doing when it refers to trace and access charges is dealing with the investigation to discover the defect, which is if you've got a water leak, where is that water leak? It's not addressing where is that damage. And we are dealing with costs, which deal with finding the damage for the purpose of repair. So rather than supporting insurers' cases, by contradistinction, it points towards investigation costs being recoverable. Of course, when it comes to working out what costs or investigation costs and other costs are recoverable, one has to also consider the position if we are correct on our appeal in relation to lifting strops, plenums and insulation, because those would then be costs referable to the remedial scheme and for the damage as at 2016. Turning to an example, which is the Mott MacDonald costs, because they've been raised as perhaps the one that do the RAG maps. And Mr. Elliott, who did them, was a witness in the proceedings. He gave evidence of those RAG maps. The costs that were charged was £687,000. That cost is a line item in the schedule. So the position is you had the general pleading, you had the specific cost of £687,000, you had a witness who gave evidence as to what he did, and what you have is the actual surveys and and relevant information being used by each one of the experts to come to their remedial scheme. You were taken by Mr. Rigney to the evidence of Mr. Coulson, who referred to them. He used them. The same is true for Mr. Jessup. In other words, this was work that was done long after 2016, but for their purpose of identifying what the damage was at 2017, but were also useful or would have been useful for the same purpose as at 2016. And so it's not, in those circumstances, and in circumstances where Sky had their own incurred costs, which the court said would be dealt with at the quantum trial, what we say it was the correct course to do is to take the incurred costs for Mace and for that evidence to be considered and determined as to what was recoverable at the quantum trial.
So what's the reference to the line item that you just, where's the bundle?
Do forgive me, I think it's in Supplemental E 65B 956.
This is the schedule.
Make sure I've got it. Yes, it's the schedule. I think it's in B. Supplemental E. Sorry.
Yeah.
And it's my notes, item 50. Yes, it's item 15, Mott MacDonald 687696 spot 72. And you will see the comments in the right-hand column of Mr. Large, who is the quantity surveyor for insurers, where he has agreed a figure as figures and makes two comments. Firstly, valuing the inspection cost to date, and secondly, identifying what in his analysis is design costs of 178,717 spot 05. And I simply have taken that as the example.
Well, it seems to suggest that not all of the 687
Yes.
are inspection costs at all. Some of them are design costs.
Yes, absolutely. But that, of course, was what insurers were saying. And my point is, respectfully, the judge couldn't have dismissed it in its entirety. And having been required to make it...
Where is it suggested that they were all inspection costs?
Not in that column, but, my lord, I hope I made that good by reference to the factual evidence. Mr. Elliott, who was called, who produced that, he was an employee of Mott MacDonald, and those were the costs. And to take the point the other way around, to the extent there was any issue over that, those questions could have been asked of Mr. Elliott, because he was cross-examined. And I don't put the point, and I don't need to put the point too high, simply that there was a pleaded and evidenced case that there was costs which have been incurred, and that, having regard to the fact there's a quantum trial, was something that should have been dealt with at the quantum trial.
You can't tell from this when the costs were incurred.
No, my lord, but we do know when all the inspections were. They've been discussed. There was 2020 with some of these inspections.
You don't actually know what a lot of these people did. It's just a whole series of company names.
But, my lord, that's true. But in a sense, in a case such as this, or in a construction and engineering case where there are vast numbers of documents and vast numbers of costs, to an extent they rely upon the quantity surveyors to do their own inspection and reach agreements to matters agreed and not agreed. I accept there's a deficiency there, of course I do. But it's not such as to say if they are recoverable in principle, a £10 million claim should be shut out when there's going to be a quantum trial anyway.
Why do you say they're recoverable in principle, though, on the basis of the judge's findings?
Because those were all those costs. Well, because the judge made a finding there was water in the roof. We say that's damage at the date of practical completion as a matter of logic. That water had to be addressed and dealt with. Its location and amount had to be identified. And Mott MacDonald were dealing with the task of monitoring, checking and verifying where that water was. And that would be a cost which is recoverable under the policy.
Assuming that the scope of the investigation was the same, to investigate damage that might reasonably be suspected to exist in 2020, or whatever it was Mr. Elliott went, as it would have been in 2016. But it doesn't seem to me a particularly safe assumption.
Because it's an
given the
assumption.
findings that there was substantial deterioration.
But the cost is in actually carrying out the inspection, yes, whether there is or there isn't. Yes. The fact that you find rather more, you even find damage that occurred the day before, doesn't mean it's not recoverable. Because if it's an insured cost, unless it's otherwise excluded, there may be more than one cause, but that's not a reason to say it's not recoverable. And the oddity of this is if Mace had been instructed by Sky to do it, and it would have been a Sky claim, those costs would have been referable and claimed as of 2017 under their under their claim. So the oddity of this is that Sky could have had the claim if they'd given the instruction, and Mace has suffered the loss. That we would say is somewhat odd and wrong in principle. There should be some sort of recovery in circumstances where a party incurs those costs for a purpose. But I don't, in a sense, I perhaps made the point I've made on that. So, my Lord, unless I can assist you any further, those are the points I make in reply.
Got 5 minutes. If you'd like to take it.
I see the time. I'm happy to start.
Yes.
Now, if you'd like me to.
Yes.
Probably best to pick one issue that I have some prospect of, as it were, making progress on this afternoon before we stop. And that means, I'm afraid, I'm not going to launch into grounds 1 to 3 of our appeal.
Right.
Because I'd rather like a clean start on that tomorrow morning, if I may. Can I pick as one issue ground 4 of Mr. Rigney's appeal, which concerns the quantum assessment hearing, if I can put it like that?
Yeah.
It is, if we may say so, a rather curious and unattractive ground and challenge. If your lordships look at the judgment, you don't need to turn it up, at paragraph 220, the judge decided that the indemnity to which Sky was entitled was appropriately quantified by reference to insurer's 2018-19 scheme, subject to 4 modifications to the temporary works, on which I should say there certainly was evidence of cross-examination. The judge directed that the parties should seek to agree the sum that would reflect those modifications, saying that if they were not agreed, then there would have to be a further hearing. And what then happened, and my Lord Justice Popplewell touched on this, there was a first post-judgment hearing. One can see from paragraph 1 of the post-judgment ruling that the judgment, the substantive judgment, was only handed down by the judge at the end of that hearing. So that there's no question that, as it were, Mr. Rigney's clients were presented with a fait accompli, a judgment that had been handed down and delivered before they had an opportunity to make submissions. At all events, during that first post-judgment hearing, the insurers contended not just that the course that the judge had taken was not open to him, but that Sky's claim should simply be dismissed, and that Sky should be awarded nothing at all. Now, that argument was rejected by the judge. You'll see it dealt with in his post-judgment ruling, his first one, and insurers have not attempted to resurrect it. The insurers did not make the argument to the judge at the time, either as their principal argument or as an alternative argument, that if the judge was not prepared to dismiss Sky's claim, he should proceed, or should have proceeded, simply to do his best and to award a figure on the evidence available. That simply wasn't an argument that was advanced by the insurers at that first post-judgment hearing. And where that leaves one is in what we would say is a slightly unsatisfactory position, and indeed one might say a slightly unfair one, which is that the point raised now, not a point raised at the time, the judge is being criticised for not proceeding in a way in which insurers did not suggest he should proceed at the time. Now, my lords, insofar as you are prepared to entertain an appeal in those circumstances, we rely upon our written submissions, it's paragraphs 39 to 54 of our skeleton argument. We would make the following points. First of all, there is no jurisdictional problem. There's a suggestion in insurer's skeleton that there is, and that the judge simply had no jurisdiction to make the order he did. That is wrong. The court's case management powers, as you will all know, are listed in CPR 3.12. Those powers, and the extract is in the back of the authorities bundle in tab 86, those powers are broad enough to allow the judge to do what he did. And indeed, that a trial judge may properly pause the determination of quantum if he or she feels the need for further help on a particular point, and may direct a further quantum hearing even when the trial is a unitary trial, is illustrated by the decision of Mr. Justice Hilliard in ACL, Netherlands and Lynch, where precisely that occurred. And as I think my Lord Justice Phillips pointed out, there was also a similar process in one step. So no jurisdictional problem at all. The second point, and in a sense that follows, is that what you are concerned with is an appeal against a discretionary case management decision made by the trial judge. Now, this court has said time and again that it is vital for the Court of Appeal to uphold robust, fair case management decisions by trial judges or first instance judges. If you need authority for that proposition, I suspect you don't, you can find it in Abdullah versus the Commissioner. It's in tab 51 of your authorities bundles. It's paragraph 26 is the relevant paragraph in the judgment of Lord Justice Lewison. And also, of course, if what one is concerned with is a challenge to a case management decision, the threshold for a challenge is very high. Again, if you look at Lord Justice Lewison's judgment in the Abdullah case, it is not enough for the Court of Appeal to conclude that if it collectively had been the first instance judge, it either would or might have taken a different course. Now it's simply not enough. So you're talking about a decision of a type with which the Court of Appeal will ordinarily not interfere, and where the threshold for interference is very high. And we simply say that that threshold is not reached here. I have 2 or 3 more short points, but I can see the time, so maybe I have to stop.
I'm afraid we do have to have a hard stop.
Yes, I think you said that. I'll finish up tomorrow.
10:30 tomorrow. Can I just say, obviously you'll use your time, the time that remains to you as you think best. But speaking entirely for myself, I would welcome as much time as you feel able to give to the retained liability issue, which has only been very lightly touched on already.
That's a helpful indication. Thank you.
10:30.
All rise again.